Hey, this is Will from Fed Employees Fight EEO Abuses. Our primary communications group, support group is over on Facebook. I invite you to join us, hang out, make comments. It's only for federal employees, and it's not because we're isolationists. It's simply that the rules in the federal environment is different than the non-federal environment. So we tend to talk about issues which we have a little bit more understanding of, rather than passing out a bunch of bogus information, right, about environment arena we don't know. Right? Isn't that fair? So, I was just looking at the YouTube channel, and there's this awesome winner, EEO winner. Ring bells for that, right? Winner, there's a 98% loss rate. Not to get you depressed or discouraged, but you got to check her YouTube channel out. She won her case, but she continues to support and empower and just share tips and advice and learn the experience what she went through. But she said one video is about community, and community is crucial during this EEOC process. One of the things that we complainants do is we feel, of course, ostracized. We've been victimized, but we're siloed. We're almost put in a prison in a cell all by itself. We feel like we're absolutely alone. There's no advice. There's no everything. Whatever little bit is out there is all for the agencies to win. And there's some lawyers out there, but we all understand the lawyers are definitely looking to self-promote. They aren't giving away anything for free. So we can really get despondent, depressed, scared, want to quit. And like the young lady said on her channel, I can't think of her name or her handle, don't quit whatever you do. Yes, be in community. You can't talk to people who haven't gone through EEO experience because they tend to shy away. They really just either don't understand or it's almost like a taboo. So you feel even more alone. Find community. Welcome. Hang out. Join our community. Make comments below. Join us on Facebook. But whatever you do, let's talk a lot. Let's team up. Let's fight and don't quit. All right. So at any rate, I want to share something which I've been reading a lot of the claims on my reconsideration request. And I was telling you that reconsideration is not an automatic, or it's not a second appeal. I've already got dunked and slammed on the initial ruling. The appeal, I got dunked and slammed. So from here, it's time to either go out to circuit court, which I'm studying now. I'm looking forward to go. Oh, by the way, I'm a pro se complainant. I do everything, have done everything so far on my own. And it's been great. It's a huge learning experience. It's been horrible, but great for learning. I'm going to tell you, whether you pro se or even if you have a lawyer, you need to study, read, review, study, and yes, talk to people. When you talk to people, you get help with managing your emotions. I think actually I got a scarlet letter put across my name. My first time around, I talked to the AJ and I was so emotional, man. She hated me. She shut me down. She didn't sanction me, but I believe silently I've been sanctioned ever since. But you can really lose it. It's one benefit of having a lawyer early on is that, this is a front person that helps express and helps you start off on the process while you're hurt and scarred and the wounds are still wide open. But the early phases actually can be done without a lawyer. So I'm at the reconsideration phase, and I'm asking them to reconsider. And I'm going to read to you claim number 7. I put some more other claims on there. Read them, check them out. I think you'll find it totally interesting. You'll get some insight as to how this EEO process goes. All right. Item J. The AJ decision involved a clearly erroneous interpretation of material facts, or CF 29 CFR 1614.405A, when she incorrectly ruled on claim number 7. Stated as, on June 9, 2017, he received notification that his position description had been modified, changing his title to IT security specialist from CSAM manager, which was a change, substitution, and mutilation of the complainant's claim of on June 9, 2017, you received notification that your position description had been modified to change your title to CSAM manager from lead audit and compliance analyst. That's a huge difference. You're changing the whole scope of the complaint. But not only that, this has implications of some whistleblowing submissions I made to the Office of Special Counsel. So it seems as though by them minimizing, eliminating my audit and compliance oversight role, it also seems to may help them in the defense on the other end. All right. So at any rate, I'll continue on. The accurate and original rendition of the complainant's claims/allegations are corroborated and verified by the August 9, 2017 acceptance of complaints of description, William Farrell, complaint number, blah, 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 right? And then I specify tab H, acceptance letter, page 130, and agency's digital submission file Farrell, blah, 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 tab H, acceptance letter, page 130. One of the things when you go through this process, you we as complainants or victims, we know we've been done wrong. We know we've been, the agency's done, our supervisors done something wrong and foul to us. And we strongly suspect it's somewhere in the EEOC category. And you can be 100% right. But what you're going to have to do is map the incident to the rules, as in the MD 110, the policy, and the law. And then after that, you have to map to certain court cases, which represents the same perspective that was one that you're coming from. See the phases? So first, you already know your incident, you know what happened to you, but you're not articulating it well. You have to articulate and translate it into legal speak. Then after you get into legal speak, what is the law, what is the policy, what's the requirement, then you also, in order to even try to have a stand, is you have to map certain law cases, similar or identical law cases to where you're coming from. I'm telling you, you have to do a lot of work. All right, I keep going. The complainant pleads that the change is not a matter of simple and harmless semantics, but is a material fact that changes the entire nature of the claim and has the potential to affect the outcome of the case. See Anderson versus Liberty Lobby, Inc. That's a court case. So that statement I didn't make up, but right there I cite a court case in which they had the same or similar issue and a ruling was made. Court precedent is always going to be important. The change is synonymous to an NFL quarterback position being changed to a linebacker. After making protective submissions, investigators quarterback changed to linebacker, but ruled on linebacker changed to quarterback. The difference is substantial because the ROI investigation investigated the complaint of position description had been modified to change your title to CSAM manager from lead audit and compliance analyst, and discovery was also dedicated to it. Is highly improbable that the Commission's July 29, 2020 order entering judgment and March 02, 2022 decision ruling of his position description had been modified, changing his title to IT security specialist from CSAM manager, was based on facts contained in the record or later reviewed de novo. So you see right there, I'm saying, hey, the judge did something wrong. How could they make a ruling, and I'll use the example, on a quarterback when it was investigated as a linebacker? It doesn't make any sense. It's like making a ruling on a police officer when it was investigated as a firefighter. Making a ruling on, I don't know, what do they call those people who work at Starbucks to make coffee? Can't think of the word. But it was investigated as a pizza maker. That's a huge difference. How could you do that? And de novo standard says that they're supposed to review the evidence without any regard to the prior ruling. Now I ask you, how can they both have made the same mistake if they both looked at the entire record and the second, which was the appeal, looked at it with new eyes? De novo means new eyes. How? Just don't line up, does it? All right, I'll keep going. See also Equal Employment Opportunity Management Directive 29, CFR Part 1614, EEO MD 110 at Chapter 9, revised August 5th, 2015, providing that an administrative judge's determination to issue a decision without a hearing and the decision itself will both be reviewed de novo. That means they have to start all the way back over with all the evidence on the record, which includes the investigation. Hey, my discovery request. I'll continue. The AJ erred when she failed to ensure that the record was adequate and substantial in her ruling of, on June 9, 2017, he received notification that his position description had been modified, changing his title to IT security firm CSAM manager. See Petty versus Department of Defense. EEOC appeal case, blah. The AJ's erroneous revision also eliminated or blunted the complainant's ability to prove that this claim was part and parcel of ongoing discriminatory retaliation and hostile work environment for his prior protected activity. The commissioner stated that adverse actions need not qualify as ultimate employment actions or materially affect the terms and conditions of employment to constitute retaliation. See Lindsay versus U.S. Post Office EEO request, blah. Citing EEOC Compliance Manual, Section 8. Retaliation, at 8 through 13, 8 through 14, May 20th, 1998. You see again, I cited the court cases. The court cases cited the manual, the policy, the law, the requirement. Instead, under the Commission's broad view of reprisal, any adverse treatment that is based on a retaliatory motive is reasonably likely to deter the charging party or others from engaging in protected activity, states a claim. ID. The complainant also contends that during the December 19, 2018 pretrial conference, the AJ was short, curt, aggressive, intimidated by not allowing the pro se complainant to articulate problems that he perceived in the process, which may have included this one. He felt bullied, intimidated, and traumatized, but it is undeniable that the AJ failed to observe and uphold Abdullah versus U.S. Department of Homeland Security, quoting Erickson versus Partis, which states a pro se complainant, however inartfully pleaded, must be held to less stringent principles cited than formal pleadings drafted by lawyers. All right, so if you notice what I did, I changed the tone. So I changed the tone, moved it from not only did the judge rule on something hypothetical, but I also moved it into the next phase and says, hey, you also improperly ruled in your de novo standard. You couldn't have done it new because the investigation said quarterback, not linebacker, right? So then I transitioned into, well, your action also deprived me, or she erred when she did not evaluate whether this complaint was part of retaliation. Now, I don't know if I forgot to put the fragmentation piece in here, but really what I meant to tell her is that, and that's a big loss, that she fragmented my complaint as well by taking that claim number, ruling on it by itself, even if she used the right title and the right name, the quarterback instead of linebacker. Even if she did that, Still, by taking it by itself, pulling it out and not looking at it in context of all the other allegations, not looking at the temporal proximity, not looking at whether the factors like did the supervisor know, then she fragmented my complaint. But lucky for her, lucky for the commission, I forgot to put fragment in on this particular one. I used it a lot on all the rest of them, but somehow I dropped the ball here. Then I moved on to say, hey, I hate to be a whiner or a crybaby, and courts don't generally look well on pro se clients as whining and crying. I said, hey, man, and that was I was describing the first time, my first experience in the EEOC realm with a adjudicate judge, and I lost it emotionally, and she kicked me square in the butt. So, here I'm whining, I'm saying, hey, but a pro se client shouldn't be held to the same standard as a lawyer. I'm not making that up. I cited the court case, right? All right, now I move to the final phases of this part of this claim. I say injustice will result if reconsideration is refused. Why I say that? Well, you'll hear in a second. That's actually straight out of a court case, right? This is a precedent, court precedent. That is, the movement demonstrates that some harm, legal or at least tangible, such as him not being able to prove his claims, the agency will continue to systemically shatter, retard, eliminate, or stop opportunities for growth of employees in his protected class with the equivalent of an ongoing iron ceiling far beyond a traditional glass ceiling, with assurances that the EEOC will be so overloaded that they will look the other way, and the complainants will not be able to rely on the integrity and compliance of the EEOC Appeals Commission. All that would flow from a denial of reconsideration. See Cobell and Julius Bank, citing FBME Bank versus Nuchin, which says even if the appropriate legal standard does not indicate that reconsideration is warranted, the court may nevertheless elect to grant a motion for reconsideration if there are other good reasons for doing so. So here I put that in there. I'm saying, hey, look, all right, injustice will flow. It's not just my opinion. It is my opinion, but not only my opinion. I'm adopting the Julius Bank case and the Cobell case. That injustice will flow if you don't reconsider. And then there's a catch-22 at the end of that. It says, hey, well, if I got it right, the courts still can do a reconsideration based on their knowledge, their expertise. And they say, all right, well, that pro se guy don't have, he don't have it all right. But we see something that is really need to be attended to. So we remind them right there that you, commission, still have the opportunity to get involved. I continue. The complainant petitions the commission to reverse the summary judgment ruling for claim number 7, then review it de novo, including the facts presented in this position and the complainant's timely and compliantly submitted June 13, 2019 claimant's motion for summary judgment dismissal/denial with its statement of undisputed material facts on pages 8 through 14, view the evidence in the record on the record most favorable to the non-movement, and award summary judgment to the complainant for claim number 7 with punitive and compensatory award, or remand the complaint for a hearing. All that comes basically right out of court precedent. So I'm not making anything up, and I'm no expert. Hey, I'm just getting the court precedent and mapping it to the instances that map or correlate real closely to what I found. It's critical. I've read tons of cases, dozens of cases, where it looks like the complainant has actually won, well, maybe a dozen cases, has actually won a little bit over a dozen. They beat, they won everything. But 2 problems. One, they never said that they were harmed. So, man, the commission toss their stuff. I say, hey, there was no harm done. He never complains about him harm. And the other one is I've read, they say, hey, well, you don't say we won anything. Like it was just a moral trip, like, hey, I just wanted to show you how justice was perverted and state my case and I'm good. No, you have to tell what you want. All right. That's it for today. I'm just encouraging you to stay empowered, check in, check on, stay engaged, don't quit, win.